We have quite a bit to talk about today, so I will be brief. But I want to welcome all of you here on behalf of the Global Antitrust Institute. When I left the Federal Trade Commission in August 2015 to return to George Mason's faculty, a friend said, well, surely, Josh, you're going to go and learn a lot of administrative law because the future of antitrust is the intersection of administrative law and antitrust. And I admit to you, even having run an administrative agency, I had no idea what that friend was talking about. Fast forward 7 years and we're here. I think there's probably no more interesting area or rich for discussion than the intersection of administrative law and antitrust. And each in their own right has some interesting topics as well. So the day will be full of conversations both at that intersection and then sort of respectively in administrative law and antitrust as well. We are excited that all of you are here. And with that, I hand things over to my friend and colleague, Tad Lipsky. Thank you.
Thank you all. Is the mic working? Great. Let's begin then. As Josh's brief remarks suggested, anytime you want to talk about public policy or legal issues associated with the Federal Trade Commission, we're enjoying what you might call a target-rich environment. Things are changing in remarkable and, in many respects, totally unexpected ways. And it's the subject of a lot of chatter in scholarly journals and newspapers and legislative reports and so on. So the function of this first panel is just to kind of get a lot of things out on the table and perhaps do a little bit of level setting, talk about some of the range of issues that need focus. And of course, we have the usual stellar panel. It's really great to be involved in another GAI event, and very grateful to the Boyden Gray Center, which has become one of the real centers of excellence on this subject. So I'm going to very briefly introduce the panelists because you have their biographies and the materials that are already handed out. They're probably well known to most or all of you. So first is sitting there on the far right, ironically, is Andrew Gavil, who's a professor of law at Howard.
I'm on the left from their perspective.
Good point. Good, excellent point. And basically, all I want to emphasize about Andy, other than he's the author of one of the leading antitrust case books, is his experience with the administrative state and with the FTC is quite intense, and he has served as the director of the Office of Policy and Planning. So that's a particularly noteworthy credential for today. And then we have Professor Thomas Hazlett, who is a professor of economics from Clemson University. And in that same spirit, I will say he served as the chief economist of the Federal Communications Commission, so knows something about how an administrative body functions. And finally, sitting right next to me is Barry Nigro. And in addition to a long and distinguished career in antitrust practice, he's not long since a stint in the Department of Justice as the Principal Deputy Assistant Attorney General of the Antitrust Division, so he knows quite a bit about antitrust. And I'm going to ask Tom to start things out with some brief remarks, which I hope will focus to some great extent on kind of the public discussion about the fundamental economic and legal issues with which we view the whole idea of antitrust and FTC as an administrator or as an enforcer of the antitrust laws. There's been quite a bit of literature about concentration and economic power and how things are changing and to what those changes are attributable. So Tom, take it away and build a base for us, please.
Thanks very much, Tad. I'll just say that if my performance is not up to snuff today, I apologize. I was injured just the other night. I probably should be on the injured reserve today, but I hurt my hand when Justin Turner struck out in the LA-San Diego game. And I'm not going to get a lot of sympathy maybe from Professor Wright, who I know hails from San Diego, but unfortunately I'm from Los Angeles. So anyway, it's hopefully that, it won't get in the way of the talk today. And I'm going to try to just do a quick breezy setup. I'm the economist, and so I'll talk about some of the issues in antitrust generally, and then the lawyers take over. This is very much in fitting with tradition at George Mason University Law School. So here we have, I think we have some slides. Let's see if these work. Antitrust in flux, how things are changing. There obviously is a political demand for more antitrust, different antitrust, and so there's a lot happening, and we know 5 reasons are right there. The rise of the large digital platforms, sometimes called GAFAM, really have changed the face of capitalism. And so it's not unusual at times of disruptive change to have a discussion about whether or not the old rules work and whether or not new rules are needed. So that's sort of just to be expected. And part of this technological change that comes with the economic disruption certainly has a distinct character. Economies of scale are very important. You see this deployed very strategically in the marketplace. There are great efficiencies, both to those scale economies that are asserted, and of course to globalization, which has had a profound impact on societies everywhere. In general, it allows the U.S. Marketplace to compete more head-to-head with many other rising countries, and you see dramatically, in fact, that, say, wages can be negatively impacted in a country like the U.S. and positively impacted in countries like India and China, and so this has political implications. Just the disruption of old industries with all the pretty amazing new stuff that comes out, well, that's a threat. That's a challenge, and in fact, that will invoke some kind of reaction in the marketplace. And so you do see this. You see it on a bipartisan basis. And one of my favorite quotes, which I did insert into a piece a couple of years ago on the topic, the president, incoming president in the United States in 2016 says, Jeff Bezos is worried about me. He thinks I would go after him for antitrust because he's got a huge antitrust problem because he's controlling so much. Trump announced his model. The European Union is suing them all of the time. Well, we should be doing this. There are companies. I always like that. It's a fairly good insight. If you can't sue your own companies, who can you sue? So we do have a couple of papers on this. My co-author and I, Robert Crandall, and one is forthcoming in the Journal of Law and Economics. And then the one I'm going to speak mostly about today is forthcoming in the Journal of Who Knows, which a lot of my publications go there, by the way. You might sort of characterize this conversation as the rebirth of Louis Brandeis and his views on antitrust. There are many papers that are important to read in this literature, and I'll just cite just a couple of them here. Not too exciting, but I'll just, for the record, say that these are all very important insights. The Pulitzer Prize-winning book by Thomas McCraw actually has a couple of chapters on Louis Brandeis opposing the consumer welfare standard and not being impressed with price decreases. In fact, fought price decreases, came out against volume discounts, for example. And this was thought to be a problem because, of course, he had an interest in protecting small business at the expense of efficiency. And that was made rather explicitly, and that view actually is had something of a renaissance in today's environment. The basic question is U.S. antitrust policy, in particular, looking at the different, the global market, is the U.S. antitrust policy too lax? Does it need to be tightened, beefed up in various dimensions? And some of the evidence purporting to support this view are pieces of research suggesting that U.S. markets are becoming more concentrated. And you see this in the four-sided report of the President of the United States, the Council of Economic Advisors, 2016. This was a theme picked up on by The Economist in 2016, who very reliably said, look at the 4 firm concentration ratios across the United States. The average has gone up over the last many years from 26% to 32%, the top 4 firms controlling 32% of the market. Well, when you think about that, that means that there are at least 9 other firms in the market having no more than 8%. And there's a lot of, so that is a view of national concentration that really, I believe, is not so compelling. Profit margins are up in the United States as a percentage of all economic activity. Some of this has to do, certainly, with the revolution just discussed. When you have software platforms or technological disruptions that can be obtained through upfront sunk investment and then amortized at a low, sometimes zero marginal cost, your profit margins do go up. You're shifting the investment to the upfront research end of things, and you're shifting away from operating costs. So that's the nature of that revolution. The labor share of national income in the United States has fallen over about 40 years from about, say, 61% to 57%. So the falling labor share is thought to be a problem with this increasing concentration. The problem for that argument, again, if you look around the world, the U.S. is actually has a very modest fall in the share of national income going to wages. You look to countries like Australia and Japan and even the European Union, you see much more of a fall in labor share. This is an issue in all the affluent countries. Also, when you talk about the correlation between concentration and profits, you run smack dab into the extremely important, deep, and influential critique by the late Harold Demsetz that when you see that the industries with high profits have high concentration, what you may be looking at is entrepreneurship. In some industries, particular firms are particularly efficient. They jump out in the lead, they garner market share, and they make high profits. That's a sign that the system is working, not that the system is restricting output and failing consumers. You see this obviously in many US markets, Amazon being one of the obvious examples. It's picked out as a characterization of the problem. Well, the fact is that they've brought retailing to a new competitive level. Yes, they have concentration in the sense that they are a very large firm at the center of that industry now, retailing, an online distributor that actually has attacked bricks and mortar and driven prices down. So that's a different sort of antitrust problem, so to speak. Finally, a lot of the big platforms are said to be buying up nascent competitors, and there's a whole list of these. Google bought Android and created, of course, their wireless ecosystem. Microsoft bought LinkedIn. This is actually the biggest acquisition. It's about number 60 in the top 100 acquisitions of all time. So it's not that high on the list, and in fact, nobody really talks about the LinkedIn monopoly or the Microsoft social platform monopoly. But these are, if you look and you go down the whole list, fairly innocuous, and in fact, that's what Crandall and I do in our forthcoming paper in the Journal of Law and Economics. Now, there's one acquisition that's also in the top 100, something like 80th in U.S. history, and that was 2014 when Instagram was purchased by Facebook. Now, that's being relitigated by the Federal Trade Commission, so maybe that topic will come up today. There are examples where this more aggressive antitrust policy is kicked in, and this is something I wrote just last year because the case that the Trump administration brought against the AT&T Time Warner merger was not successful. The merger took place, unfortunately for AT&T, because as soon as they had the ability to allegedly, as the this is a Department of Justice case, after they had allegedly the vertical power to hurt competitors, direct competitors to the broadband distribution service of AT&T, they immediately found that it was not worth anything. In fact, it was worth a large negative number, and they ended up unloading Time Warner for about half of what they had paid for it just a few years before. So we've run through that. We've also had a successful policy that some people, particularly states' attorneys general, were very interested in litigating, and in fact did litigate and lost the case against the merger in 2019-2020. T-Mobile did acquire Sprint. We went, by some counts, from a 4 to a 3 U.S. mobile market. That was supposed to be indicative of excess concentration. And despite the fact that, for example, most EU companies have gone 4 to 3 already, but the argument was that T-Mobile acquiring Sprint would become a much more aggressive and successful competitor against the two leading firms, AT&T and Verizon, in the industry. And in fact, that's what's happening. So there's a very successful outcome thus far to the liberal policy. You can see this in a lot of ways, but certainly in developing 5G networks, this revitalized and larger T-Mobile, which is now about the same heft in terms of subscribership and revenues as the two larger, traditionally larger carriers in the industry, is producing a lot better quality product than they would have been likely to without the merger. And in fact, winning the third-party evaluations in terms of best 5G network. So the speed, just showing the speeds and so forth here, that's actually a feather in the cap of U.S. antitrust policy. It allowed something that a lot of the new Brandeisians would object to, did object to, lost in court, and I think that the antitrust policy that prevailed certainly has some very obvious pro-consumer outcomes to talk about. Thank you very much.
Thanks very much, Tom. That was incredibly well organized and effective. I really appreciate it. Before we go on and pass the floor to somebody else, I guess I'd like to ask the other panelists, if they want to react to anything that Tom presented. One of the things that I was really hoping that we would address, and Tom has addressed, is this kind of drumbeat that began with the Council of Economic Advisors report in 2016 that came out talking about increased concentration, increased monopoly power, and all the profits and so on and so forth. And to me, it was surprising the speed with which, because of various sympathetic NGO reports and congressional proceedings and other contributions by the media, like the Economist article that Tom mentioned, it almost seems to be accepted in the public mind that there's some kind of a problem with industrial competition and structure in the United States, and I don't think that's a fair characterization. I wonder if there's anybody on the panel who wants to defend the other point of view.
I mean, I'll say I don't know that it's as accepted as people think it is. There obviously is a lot of noise out there calling for radical shift in antitrust policy, but fortunately the courts are continuing to apply traditional antitrust law the way it's been applied for the last several decades. And you see that reflected in a number of the recent decisions that the agencies have been confronted with at the FTC with the Jewel case and Illumina Grail, and on the DOJ side with United Healthcare Change and the Sugar case, the Booz Allen case that just came out. We're still waiting to hear on publishers. I'm personally expecting that one may be a win for DOJ. We'll see, but I think the courts are still looking to apply antitrust law the way they always have, and maybe we'll talk about this a little bit later. But one of the things that the agencies are trying to do now is, rewrite the guidelines, and that somehow that's going to magically change the law and immediately be embraced by the courts. But one of the challenges, and I think Andy Gavil mentioned this the other day when we were speaking, is that the courts have actually embraced the existing guidelines to some extent, and that didn't happen overnight. It happened because they, through an iterative process where cases were brought, and based on the facts and the law, the courts gradually embrace the guidelines more and more. And I can't imagine that they're just going to sort of turn on a dime and say, okay, we were wrong. Now that the guidelines have changed, the law must have changed, and we're off on a new path. So I think it's going to be much more difficult for the agencies to change law through policy, and that's because we have fundamentally a law enforcement regime, not a regulatory regime, and I think that's a good thing.
Andy?
Tad, I would add that I think it's not a binary yes or no question. I think there are degrees of acceptance of the criticism. And I think one of the challenges of our time is that although the loudest voices may be at sort of the extremes, everything's fine, blow everything up, there's a lot of disagreement along the spectrum and different views. And two concrete examples. John Baker's book, now almost 2 years ago, The Antitrust Paradigm, sort of steps away from the concentration debate and says we have a market power problem. And he tries to, in his book, he tries to document and support that particular view. S2992 is, I think, a very interesting study because that has caused a split among people that you might predict would be in agreement along a spectrum. There are people you would associate with stronger antitrust enforcement who are taking the view that we do need to strengthen antitrust enforcement, who are concerned about that bill. I'm included in that group. There are others who are suggesting that the bill is good and we should pass the bill, it's the best we can do. But when I see that kind of split among people who usually agree with each other and who are agreeing that we need stronger antitrust enforcement, I'll talk a little bit about why I think that's so later. But I think that tells you that it's a more nuanced, complex problem than are you for or are you against the critique. But the critique is historically interesting to me as well, because the critique of the old antitrust that eventually began the process of change in the late 1970s, that, as you said, Tad, that took decades also. And that wasn't like a sudden departure from prior antitrust. So that's something I hope we'll unpack a little bit more as we go along. But I think it's important to see that there isn't sort of a clear coalescing of views, and that's part of what's making this period complex.
Andy, do you have, you don't need to answer this if you feel you don't want to, but I'm curious, what is your reaction to Tom's description of the way these merger cases have been proceeding and coming out? I don't know if you follow, I assume you follow all of these cases very closely, but.
Oh, very closely, every single one.
But I'd be curious to know if you have any net reaction to kind of the way this merger enforcement is going in these sectors that Tom has been describing.
So if I had a blackboard, I would write the word rhetoric greater than reality. And I think that that's a part of our time right now. When you look at those cases, I think they both illustrate the problem and illustrate that there is no problem. They're not especially expansive or creative. For all of the criticisms of the so-called neo-Brandeisians, and I'd like to come back to that because I think that's a catchy title, but it's not really what Brandeis did when he was on the Supreme Court. It may have been what he said, but that's another. But these cases, they're losing relatively conventional cases. There's nothing unconventional about vertical cases. There's nothing totally unconventional about some of the cases. But the law has become very demanding. So rather than say we have a concentration problem or a market power problem, my view is we have an antitrust law problem. And the antitrust laws have drifted in a direction of increasingly high expectations of economic precision to the point where burdens of proof, use of presumptions, use of inferences has become problematic. And you see it in private cases, every bar that can be raised, burden of pleading, burden of production, burden of proof, class action certification. This has happened again over decades. And it represents a skepticism of antitrust. It represents a skepticism of the private right of action, a skepticism of treble damages, a skepticism of e-discovery. You look in a case like Twombly, and there's a big footnote about, well, that's the scary cost of discovery that leads us to raise the burden of pleading for everyone. It's a bigger picture, and I think we do have an antitrust problem when it becomes so difficult to win relatively easier cases. So I would say to your question, Tad, that the losses I'm seeing are not because the agency is reaching out for creative, extreme, push the envelope theories. They're doing some of that, but they're losing even unconventional theories because the burdens are so demanding and the evidentiary expectations are so high.
Couldn't resist, could you?
No, I mean, we've seen this movie before. I mean, with hospitals back 20 years ago, the FTC had a string of losses in hospital cases. I can't recall if it was 7, 8, or 9 in a row. And what they did is they stepped back and they said, let's do a 6B study and rethink how we're approaching hospital cases. And so they did a retrospective, got the data, the economist looked at it, worked it, and out of that case came the Evanston Northwestern case that was brought in Part 3. And following that, that exercise, hospital merger enforcement got back on track. And I think it was a product of the learning that occurred by sort of stepping back and looking at, are we litigating these cases the right way? And I wonder if some of that needs to happen now before we throw the baby out with the bathwater and try to address particular concerns with platforms and the GAFM, as Tom said, because I don't know, at least I'm not persuaded that antitrust law is not working with respect to the rest of the economy. I understand that some of the tech platforms are different, the economics are different, but I'm not convinced that it's not working with the rest of the economy. And some of the cases that the agencies have lost on, when you go back and look at the facts, there's an argument that it's understandable why the judges had struggled with those cases. So I don't know that the situation with the law is as dire as Andy may think. I agree that there's always room for improvement, and that having these sorts of debates about whether the law needs to be tweaked here and there, I think that's a healthy thing. It doesn't necessarily need to be stagnant, and can benefit from change over time. But I'm worried a bit about the pace of the change and the scope of the change. I don't know that like a seismic shift is needed. I think it's worked pretty well, and we can talk separately about enforcement resources and whether the agencies. I mean, the agencies, frankly, the staffing hasn't kept pace with inflation, and their headcounts are way down from where they were 20, 30 years ago. So that's contributing to some of the challenge that they're facing.
I think I would agree with Barry in this. I would say that the rhetoric for either sinking the ship or completely turning the ship in some major way is wrong. I do think we need some course corrections.
Before we leave this sort of general economic background and the broad context for what we're going to be talking about in the rest of the panel and the rest of the day, I wanted to pose this very broad question. I think, Tom, primarily looking for your reaction, but obviously others are welcome. I look back at some figures for GDP and noticed that in the first quarter of 1980, which was when, 1981, forgive me, the US GDP stood, when Ronald Reagan was inaugurated, at about $3 trillion. And the GDP of the nations, the 28 nations that ultimately comprise the European Union, pre-Brexit, of course, was also about $3 trillion. If you look at the inflation-adjusted GDP figures for the first quarter of 2020, which was the last quarter before the COVID shutdowns, the European countries' GDP was 15 trillion. So it expanded essentially by a factor of 5. And in the United States, the corresponding figure, also inflation adjusted, is 21 trillion. So the US had expanded by a factor of 7. And if I could also, I think you see where I'm going with this, I would also mention that if you look down any list of the top companies in the technology sector, or indeed in any part of the private sector, I'm excluding things like sovereign oil companies, you'll find mostly U.S. companies. You'll have to look down a fairly long way to hit companies from Europe like SAP and what have you. But my point is, we stand in, the U.S. antitrust policy has stood in marked distinction to that of the EU over these many years. And of course, I think it would be foolish to attribute all of that or any significant part of that change, the success of the American economy compared to the EU economy. I think it'd be foolish to attribute that too much to antitrust, but I can't help feeling that there's some element of that goes into the mix. And so, Tom, if you see where I'm driving, I'd love to hear your reaction. Other than you'd need a lot more data and a lot more thinking in order to come up with any causal link. But
just say that.
Further research is needed. It's a point that's well taken, and the fact is that there's a lot of confusion, a lot of assertions, even by prominent members of the debate, that the U.S. is lagging behind. Our antitrust has fallen back, and therefore the European Union is doing much better in things like cellular and broadband. It's just not true. The U.S. markets are fairly robust. We've made some mistakes, certainly, and I'd be happy to give you 31 Hazlett references on explaining them in some detail. But the other markets don't do things perfectly either in terms of their policy or business strategies. And straight up like this, if you look at the high-level numbers, you're very impressed by U.S. growth. I mean, there has been U.S. growth. It certainly led the world in terms of the entrepreneurship into the digital era. If you do there's an annual Silicon Valley report on the top 30 tech firms in the world. The last one I looked at was a couple of years ago. I think it was pre-COVID. It was striking. The top 30 most valuable tech firms in the world. No, they're not all U.S. Okay, there's, I don't think, 7 or 8 are Chinese now, and they have certain other mechanisms for market share that maybe aren't what the rest of us might apply. But the U.S. is certainly dominant. In the entire list, there is one firm based in Europe, and you probably couldn't even guess it. It's number 30, Spotify.
Oh, Spotify.
From Sweden. As we say in South Carolina, bless their heart. Okay, so the Swedes got one in the top 30.
Yeah, sure.
And you go to conferences in Europe, and you do have Europeans saying, how can we get more investment in research and development, more disruptive technology, like the US, for example? I mean, that's what the discussion is. Then when it goes to public policy, it's all, well, the US has these bad policies, and we have our own policies, and then you get on a completely different track. And so there is a problem and a disconnect that needs to be smoothed over. And certainly in the U.S., we shouldn't have any problem sort of ferreting these things out, and maybe go against the logic. If they're your companies, you ought to spend more time suing them.
Great. Well, let's try to transition here. I've really enjoyed this discussion about the broad background, and I'd like to get us to look at what's happening down on the killing floor. We have had so much activity at the agencies. Some of it may be lightly anticipated in the prior administration, but certainly a huge change as the personnel were replaced following the last election. And Barry, I'm going to look to you to kind of summarize. Rather than make my own list, I'm going to let you summarize what you'd like.
Sure, thank you. So I'm the practitioner on the panel, and I'm still working for a living, so I need to be mindful of that. Working with the agencies now is become a bit of a challenge, and having recently left the Department of Justice and having served at the FTC, I have a lot of respect for the mission and understand the importance and agree with Jonathan Cantor that competition's critical to capitalism, but it's also critical to incentivizing investment and taking the risk that result in getting so many companies at the top of the list that Tom was talking about. And if we aren't mindful of the importance of that incentive, we're going to compromise that advantage that this country has when it comes to how we apply competition policy in order to stimulate more investment and ultimately more productive output. So I think it's important how the agencies approach their mission, and we're sort of looking at wholesale change on the march at both agencies. We see the consumer welfare standard is under attack. There is the executive order that was discussed. That executive order, if you look back at the Sprint T-Mobile case, I mean, one of the things that happened in that case that doesn't get talked about is the FCC agreed to the party's offer of a price cap, and there were no damages after that. So where's the harm? How do you go in front of a judge and explain the harm? And a number of states tried and were unsuccessful. So I think part of the goal of the executive order, when I read it, I didn't really read it as talking to the FTC or the Department of Justice. I read it as speaking to the agencies. You need to get in line behind the antitrust agencies and support their efforts to bring more cases. And so I think that's what that order is really driving at, and I think that's how it could have an impact going forward. Then there's a desire to change the merger guidelines and combine the horizontal guidelines with the vertical guidelines, rewrite them. There'll probably be a draft out sometime before the end of the year, I'm expecting, and I think they're going to be radically different from what we've seen in the past. So it'll be interesting to see how that moves forward. There's I think less value given to efficiencies, which I always viewed as a good thing. I would think we'd want to promote efficiencies. There are questions as to whether there's any merit in even investing the time and money to try to prove your case based on efficiencies. So it makes me wonder, aren't efficiencies a good thing? Aren't lower prices a good thing? I mean, if we're ultimately trying to benefit consumers through competition, I would think lower prices would be a good thing, but it's not always clear what the objective is here. There are, I think, increased challenges in responding to requests for information, whether they're second request or other forms of compulsory process. That's become a much more challenging exercise and incredibly expensive to the process. So there's a lot more friction there. The approach to remedies that Macon, when he was AAG, gave a speech, one of his first speeches preceding the challenge in AT&T Time Warner, where he raised questions about the ability to effectively police behavioral decrees and some of the challenges there. And now we're in a world where I think the policy is we don't like remedies at all. So even straight up divestiture remedies are not necessarily acceptable in all cases, although I find it ironic because the FTC just signed off on Tractor Supply, which is a huge retail divestiture of 80-some stores, I think. And to the extent the remedy policy is based on concern about problems with remedies, all the problems with remedies have been focused on retail divestitures, like Dollar Store and Hertz and those sorts of things. So I was like, wait, we don't like remedies, but we're okay with this one. So I'm wondering, does the FTC have a different policy from DOJ, or we're sort of in this state where it's a bit confusing as to what the agencies are okay with and what they're not okay with and why. Prior approvals, there's now a big push to put prior approvals in consent decrees, and that was something that was popular the last century. The agencies got rid of it for a reason, and it's a bit concerning because it's not prior notice. Prior notice, fair enough, if you're in a market that's concentrated and you're worried about incremental acquisitions that are not reportable, and you want to get some notice of that and have an opportunity to look at it because you think that the parties are already at the line. That's fair enough. But the prior approval is just what it sounds like. It's totally up to the discretion of the agency whether to give you a thumbs up, thumbs down. There's no timeline associated with it. There have been situations in the past where prior approval applications have been sort of lost in limbo for over a year. One of them resulted in a criminal contempt proceeding because the parties, I think, at some point gave up. And so, and what's the standard for getting prior approval? Is it a Section 7 standard? I mean, it seems to be totally up to the discretion of the agency. So it's almost like a whole nother regime that's not subject to review in any way. So, very different from prior notice, but to be expected now in any settlement that results in a decree. And there are warning letters that come out now on a regular basis, mostly from the FTC, but some from Justice. And people are trying to figure out, well, what's the import of a warning letter? What does it mean? It's always been true that the agencies could challenge a merger after it was consummated, even after it went through the Hart-Scott-Rodino process. We did that with Parker Hannifin. Something was missed. It was a merger to monopoly. It was addressed, and the law is always allowed for that. Doesn't happen very often, but when it does, there's a process. It seems that warning letters are being issued as a matter of course on transactions, and it's not clear why. So parties, are now building into merger agreements provisions that say that a warning letter doesn't compromise any of the closing conditions. That you still have to close despite getting a warning letter. There was a temporary suspension of early termination that happened way back at the beginning of the administration, and it was advertised as temporary, and it's been over a year and a half. And there's been no discussion about when it will end and why it's still needed. And the thing is, early termination was at the discretion of the agencies to begin with, so it wasn't clear to me how that created more burden, and it did allow the agency the ability to grant early termination in situations where there were compelling reasons to do so due to things beyond the control of the parties. So that's no longer available. The agencies are broadening the aperture on Section 2 on criminal enforcement. They've talked about bringing Section 2 criminal cases. It's happened in the past. It is in the statute, but it's unclear sort of exactly what they have in mind and how that's going to be applied. I mean, I think the guidance was, we'll look at the past cases, but we're talking about some cases that are fairly dated. So, some more guidance on that would be welcome. And then, recently, a few weeks ago, Commissioner Bedoya talked about sort of reinvigorating the Robinson-Patman Act, which, is still alive and well, and they're private Robinson-Patman cases, and I think there's some Robinson-Patman lawyers out there. I don't know many. And I still remember from when I was young, looking at Robinson-Patman issues and writing memos to clients and all of that. But for the past 20 years, it's really not been of any interest to the agencies. They kind of reached the conclusion that it on balance did more harm than good. So, but it's on the books, and there are private actions here and there. So it looks like that's something that firms need to keep on be more sensitive to, because at some point I think the agencies are going to be more active there. So there's a lot. It seems like there's a lot that's happening, and it's all happening at once. And it's if you go to the websites of the agencies and try to find things like the Antitrust Division Manual, it's not there. So at least it wasn't when I looked a week ago. Maybe it's there right now. I don't know. But so we're in this sort of transitional period where there's an effort to make this seismic shift in enforcement and to use sort of the regulatory machinery to change the law and change how it's applied. And as I mentioned earlier, so far the courts have been skeptical of some of the recent cases. In fairness, some of those Jonathan had just landed. He hasn't even been in his position a year. I think it was confirmed in mid-November, and so he's coming up on a year. But I do think that both the FTC and the Department of Justice are going to be climbing a steep hill in order to sort of implement some of the policies that they've articulated. And even at the FTC's administrative law judge, Judge Chappell, who's been there for a long, long time, and where they frequently prevail, they've lost 2 cases in a row in front of Judge Chappell. So even the ALJ at the FTC is asking questions about some of the cases that have been brought. So,
Well, Andy's looking at me because he knows my next question is for him, which is, let me put it this way, Andy. Based on this very cogent and complete list that of what's been going on with merger policy, and particularly FTC, and merger practice and procedure and speechifying, I don't think it would be too unfair to say that the FTC, at least, just doesn't like transactions. It just doesn't like corporate acquisitions and wants to discourage them any way it can through hostile changes and substantive rules, through this long list of little petty procedural changes that are, I suppose, although I don't want to prejudice anybody's lawsuit if they want to challenge them, but I suppose, for example, eliminating, making a practice of not granting early terminations is, or this business about sending you a letter saying, well, we know your waiting period is about to expire, but you don't read anything into that. It seems like that's kind of the net is that they just don't like transactions and are going to discourage them in any way that's available. And I guess part one of the question is, do you agree with that? And part two is, if you do, is that a great idea? Do you support it or something else?
Sure. So changing business as usual is disruptive. And lawyers who have practiced in a similar way for a long time view it as disruptive. Clients view it as disruptive. I'm not going to go through the list and try to, defend or oppose any of those measures. But I will say this: in 1982, when the new merger guidelines came out, the antitrust bar was pretty kind of scratching their head, mystified by the hypothetical monopolist test. They wondered about the HHI. Change faces resistance, and it took a long time. As late as 1990, in Baker Hughes, the DC Circuit was saying, we don't know where you got this entry stuff in your guidelines from, but that's not what the law is. So let's not forget little historical context. Change is difficult, and change when you're trying to ramp up enforcement is a lot more difficult than when you're trying to ramp down. So another difference, I was going to talk about this a little bit later, 1981 versus 2022. There is clearly messages that they're trying to send. And again, I'm not going to defend every little procedural thing that they've done. How they go about it concerns me as well. But it is harder to do. Like I said, if you really think the ship is headed in the wrong direction and what you want to do is ramp up enforcement, it takes time to develop cases, it takes time to develop new guidelines and theories, and we are not very far into this administration. Remember that it was 1984 in the Reagan administration before you started getting this real push with amicus briefs in the Supreme Court that year. In a series of important cases, Jefferson Parish, Copperweld, NCAA, where the government really started to have an impact on the Supreme Court. These things take time. And so, I'll say flat out, I want the FTC to succeed. I think that we are better off with it than without it. I want Lena Khan to succeed. Am I concerned about some of these procedural things? Yes. I actually had a couple of questions for Barry. But we are clearly still in a very early period, and it's disruptive for clients and for practicing lawyers when you're being told something very different. And I think Barry's right. There is a message of, we're concerned about transactions. They're being very explicit about that merger policy has been too permissive, and we want to send a message of a higher level of scrutiny. Whether they're doing it in the best way, I think we could debate that. But I think that they are as clear in their message as Bill Baxter was in saying we're headed in a different direction now. And there was resistance to some of the specifics back then. If I can, I wanted to ask Barry one specific question, which is whether or not he thinks clearance is more, less important, less consequential, the same. Are you seeing that becoming an issue for parties?
It's ongoing debate, clearance, and sometimes it works well, sometimes it doesn't. So you've got the sort of friction and uncertainty associated with it. So that's one issue. But are you asking whether it matters which agency you're at?
Yeah, whether your perception is that because do you really see the FTC and the DOJ as moving in the identical direction, or are there differences that you think make clearance more consequential than it was before this administration?
I think that in some respects it can be consequential, and part of that is related to resource constraints. It also, I do think there are some differences in how the agencies are approaching merger enforcement. So, I don't know that the Tractor Supply consent decree would get through DOJ right now. But it seemed to have gotten through FTC. There have been a number of consent decree, divestiture decrees coming out of the FTC. Last time I checked, I don't think there's been a single one out of the DOJ since Jonathan arrived. So, there have been deals that have gone through. There have been deals that had divestitures associated with them or were coincident with the deal going through. but no consent decrees. So there are some differences on the margins, and I think whether it matters depends on your particular deal, the industry, and how you think, where you think there, if there are issues, where you think they are, and how the agencies will deal with them, because I think it's going to be very fact specific as to whether you prefer to be at one agency or the other right now.
One thing I've wondered is, when you're going to the FTC, it's almost like you have multiple constituencies that you have to be prepared to address. And there may be, divisions between where staff is, and it's unclear. It's a different relationship between staff and the leadership. How you approach the different commissioners, how you approach the ALJ if you've got a Part 3 proceeding, how you prepare a record for the court if what you're doing is kind of giving up and thinking, we're just, they got the 3 votes, we're going to lose. Seems to me that that's one of the complications right now, is it's almost like you're dealing simultaneously with multiple constituencies.
Yeah, there's less of that on the DOJ side, partly because of just structural reasons. There's one decision maker, and I think Jonathan's assembled a strong litigation team, and he's been doing this a long time. I've practiced with him for a number of years, and he knows what he's doing. So he's got a very strong team. So I agree with you that it's still early, and I think his last political spot, I might be wrong about this, but I don't know if he has any others here or there, but was just recently filled. I mean, and Michael Cadis, who used to be at the FTC, I worked with Mike when I was there. He just joined as a deputy not too long ago. Andy Foreman also recently joined. Andy's been worked with Jonathan since he was back in 2000 at Fried Frank. So I think he's got a very good team, and from what I can tell, they're working well together. And I expect that that some of the challenges that they're facing with the courts, that's going to turn around at some point, given the quality of the litigators that they have and Jonathan's vision. So while they're dealing with some challenges now, I don't think that's the way this is going to play out long run. But institutionally, the FTC is structured very differently with the bureau and the commissioners. It's at the staff level, both agencies pretty much operate the same. It's what happens after that, where the differences can be consequential.
Tom, I know economists rarely concern themselves with these grubby little details that the lawyers are forced to confront, but did you have any comment on this part of the conversation?
No.
More research is needed.
More research is needed. It does remind me, though, that I mentioned the T-Mobile case. I was one of the experts retained. There were a large number of economists retained by the merging parties, and I was one of them. But at any rate, I wanted to make that disclosure.
Congratulations. Well done. I'd like to shift the ground now, and in the concluding time that we have left, in addition to the possibility of audience questions toward the end, as to which I'm not sure what the procedure is, but I do want to kind of introduce an additional degree of freedom to what we're thinking about, in the sense that so far I think we've been talking about the development of the commission and the commission's antitrust policy within the framework of existing law and practice, and how it's being changed here, at least in the short run, and starting to think about the long run. But of course, everybody's aware that there are these massive, dramatic proposals pending in Congress for all kinds of changes to antitrust law. Everything from repealing or overruling every Supreme Court case since General Dynamics, to changing the merger standard under Section 7 of the Clayton Act, And I'd like to turn the mic over to Andy, who's going to describe a little bit about what the world might look like if you consider these broader proposals, and maybe talk about the kinds of changes outside our current box that would seem advisable.
Sure, thank you. So I wanted to start this segment by going back to something I alluded to earlier, 2022 versus 1981. Jonathan Cantor has used the word inflection point in, well, that's two words. He's used the words inflection point a couple of times in some of his speeches. And so I'd like to start this segment by asking, are we at an inflection point? Are we at a point where things are really going to move in a very different direction long term? Understanding, as I said earlier, that I think that that's a process that takes time. But is this moment conducive to that kind of change? And I want to draw a little bit of a compare and contrast with 1981. So one thing that was really true in 1981 was that there were really at that point decades of criticism of many of the leading antitrust cases, especially the antitrust cases in the 1960s. There is criticism today, but it's not decades of criticism, and it's not as deep. It's in a sense, it's a still forming criticism, but Tom reviewed some of it, and it's being debated, but it still seems like the criticism, the critique of the current law is in relatively earlier stages, but as I said earlier, I would count myself in the group of saying I'm not happy with the current state of antitrust law. I think it has drifted in a direction of being far too demanding. But what about the rest of it? Political winds were changing in 1981 in a major way. The Supreme Court had changed in a major way that made it much more receptive to change by the late 70s, even before the Reagan administration took office and into the 1980s. But you had the 4 Nixon appointees, you had Stevens. The court was a very different court that was receptive to the message. I wrote an article many years ago about Powell's role in Sylvania and Monsanto. And I asked one of his clerks if he would characterize Powell as a Chicagoan, and he said, no, not at all, but the Chicago critique resonated with him as a business lawyer. So is this court receptive to the kind of change that is being promoted for more progressive antitrust? Not really a rhetorical question, because we all know the answer is no. There was a durable effort. There was 8 years of the Reagan administration, as we talked about before. They saw the opening in cases like Sylvania and broadcast music, and even National Society of Professional Engineers, which was a plaintiff's win, but it really emphasized the role of competitive effect. And Sylvania and BMI were emphasizing the role of efficiency. By the way, none of those cases used the phrase consumer welfare. And that's a kind of a separate discussion, but I think that that's a little bit of mixed up conventional wisdom. It's not until Brook Group that a majority decision uses consumer welfare in the way that Bork intended it and associated it with higher output, lower prices. That's Brook Group. It appears in some dissents before that, and it famously appears in Reeder versus Sonotone in 1979, but that's a case about Section 4 of the Clayton Act and consumer injury. And they pluck the quote from Bork from a year earlier and say, well, of course, consumers who pay high prices, by the way, for resale price maintenance, which is what that case involved, are injured in their business or property. So the period of change is long. There were decades of criticism, decades of changes, a receptive court, a change in the political atmosphere, and they were ramping down instead of ramping up. Is that where we are in 2022? And that brings me to the, answering Tad's question about our last segment. Are we really poised for a big change? Are we at an inflection point? And I talk about sort of 2 examples to say I'm skeptical that we're there, even if I think things should change, but I'm skeptical about this sort of big change of direction. The first is the merger guidelines, and I think as Barry mentioned, in our prep call, we were talking about what's different today about changing the merger guidelines. The formal view of merger guidelines since 1968 has always been that they're just about enforcement policy. They're not about the law. They're not about burdens of proof. And yet the success of the guidelines has changed that. Because when you start looking especially at district court decisions where the guidelines have been urged as more than just guidelines, they have been written into law. Courts use the HHIs. Courts use burden shifting, and they talk about market definition, and they talk about market shares, and they use the HHIs, and they use the hypothetical monopolist test. The agencies have been using it when they go into court. Are they still trying to use Philadelphia National Bank? Yes, but there's a whole lot more to what's happening in the courts. And so I think at this moment, if we want to ask, is there an inflection point? Can the agencies just announce new guidelines that look more like the 68 guidelines? I think they're going to face a different kind of challenge in doing that, given that the guidelines' success has gotten them written into law. The second point, and I know this is one of the main goals of today's conference, is to talk about rulemaking. And regardless of where you come out on whether the FTC has authority for competition rulemaking, MAGMOS, consumer protection rulemaking, some combination, I think that what we're seeing is kind of hybrid rulemaking, using the MAGMOS procedures, but including provisions that are justified on competition grounds. Regardless of where you come out on that, this is a particularly inopportune time, given cases like AMG Capital, given cases like EPA, the West Virginia versus EPA, to be pressing for broader administrative authority. And I know this is going to be the discussion most of the rest of the day, and so we wanted to set it up a little bit. But it gets to my point of, are we at an inflection point? Well, in terms of that, looking at the administrative decisions of the 1970s versus where the court is today, I think there's going to be a lot of skepticism, and that's going to be a harder path to go, given where the courts are. And so you come around to the big question, I think Bill Kovacic will be talking about this. What does a program look like today? If you do want to change the law, if you do want to move in a direction, where do you put your resources? What are the most receptive pathways to change if you want that? Are we going to get legislation? Right now, it's not looking much like legislation. I'd be happy to talk about why I oppose so-called ICOA, but the two bills that are getting the most attention are ICOA and the horrible idea that we should let save journalism by allowing cartels. And I find myself, as I said, I believe that we need more progressive antitrust. It's uncomfortable for me to say that I don't really like either of those bills. I think they're based on bad bipartisanship, if there is such a thing. The interests behind those are very troubling to me. So with that, I will invite opening up for more questions about our final segment here.
Yeah, well, Andy, you always disappoint me when you make so much sense. But thank you very much. Let me just ask the other panelists to react to what's been said, and maybe if you have your own views on all of this legislation that's running around and whether anything is likely to come of it or anything should come of it. And if I could just very briefly inject one other facet of the legislative discussion. It seems to me a lot of the heat and motion in the antitrust area is generated by the impact of GAFAM. The really was Tom's opening theme, and so we have this kind of split that's emerged. We have a number of proposed general revisions to the antitrust statutes, all of which strike me as very bad ideas. But then you have a number of other proposals that are essentially narrowly targeted on perhaps the issues associated with the digital platforms and the GAFAMs and so forth. And if Tom or Barry want to react, if you could comment on this whole notion that maybe what's really going on here is we're about to give birth to a new specialized regulatory approach to some of the problems of the digital platform. So let me turn it to one of you. Volunteers accepted.
I'm not an expert on the legislation. I haven't read it from front to back or studied it in detail, but anytime legislation that is being passed that's as significant as that, it makes me a little bit nervous, anxious, because the implications may not be fully understood, and my general sense is that they haven't been fully studied. That's not to say that there isn't room to make improvements. So if there are concerns about tech companies acquiring nascent competitors, and that is, if that's a unique an issue that requires special attention, and you want to make sure that those types of transactions get reviewed by the agencies, maybe take a look at what Germany's done with their lowering the thresholds on tech companies, and let's look and see if that's worked over there. Has that helped or hurt? And maybe there's room to make some adjustments to deal with some of the unique circumstances associated with tech acquisitions. But on balance, I even if you believe that there's room for improvement, some of that can come through thoughtful enforcement, and maybe doing something like the FTC did with the hospitals back in the 6B study, using that more to make sure that the decisions are considered and based on data where you can actually see what were the price effects in particular circumstances, and were there deals that went through that should have been challenged, because the agencies aren't perfect. They're trying to sort of base enforcement that's supposed to be forward-looking, but always relying on historical information because that's what the courts demand. And I don't know how it's hard to get around that. We use economists sometimes to do it, but you have the competing economists, and then the judges kind of throw up their hands and not sure who's right or who's wrong, because it sometimes is over everybody's head. So I'm supportive of a more incremental approach to addressing some of the concerns. I'm worried about spillover from passing legislation that seems to be driven by the big tech companies, the GAFAMs, that will necessarily have an impact that's much broader and could be detrimental in some cases. So maybe it's good, maybe it's not, but I haven't seen anything to persuade me that it necessarily makes sense for the entire economy.
Tom, just before I turn the floor over to you, I just wanted to jump in on one point. Barry, you made the observation that these legislative proposals have not been especially well vetted, and I think that I believe it is still true to say, and if it is, it's really something that deserves a lot of emphasis. The Sherman Act, the critical provisions of the Sherman Act, the key language of the substantive prohibitions, has basically been untouched since 1890. There have been procedural changes, remedial changes, and of course, the practice and the fines and class actions, that's all evolved. But the substantive provisions are now exactly as they were in 1890. I believe it's true to say that none of the current legislative proposals has been the subject of a legislative hearing. There have been informational hearings where people were brought in to complain about the conduct of this firm or the conduct of that firm. There have been markups, but other than that, there has never been the traditional process of proposing specific legislation, putting it in front of experts and panels subject to questioning. And the idea that you would change such a major, basic law that has been viewed as adequate for that length of time, essentially you change it in the back room, just kind of surprises and disappoints me. And it's something that I think an aspect of the legislative process, of this legislative process, that deserves more recognition and attention. So that's my 2 cents. Tom, take it away.
Thanks. Yeah, there are a lot of wild swings being taken now, not just on the baseball field. You see, stylized facts develop. For example, the argument against Amazon that's driven so much of this thinking, that they're self-preferencing, and they've created this magnificent retail platform, but now that they're moving out the third-party vendors. You just look at the simple data. Amazon started 97, 98 at 100% Amazon product. They weren't a manufacturer, but they contracted and they sold Amazon products. Today, they're about 36% Amazon in terms of the actual retail sales. They are a third-party platform, and that's how Amazon has reaped enormous profits, that plus integration, obviously, into the cloud. And it's become a platform for independent competitors to Amazon. That's what the market is telling us. Those third-party vendors go to Amazon. By the way, they could go to eBay, where there is no self-preferencing, and eBay was much larger to start with. Now they're much smaller. They can go to Shopify, by the way, which is a Canadian firm, and it is in the top 30. When you're Europe and you're behind Canada in the top 30, that's something. The digital regulator idea, this comes out of the Stigler report, the University of Chicago, the idea that there should be a new specific industry oversight. This goes right in the face of what we've learned about rent seeking and capture. And I do want to mention, Andy makes a good point about the 1980s weren't obviously a vacuum, and you had a run-up. You had particularly the 1970s, came right before the 80s, if memory serves. And you had the deregulation wave of the 1970s, and that was, of course, really not a Chicago phenomenon. And in fact, one of the key players, Fred Kahn, born and died a very loyal New Deal Democrat, and this was a learning process. We saw the behavior of the Interstate Commerce Commission, the Civil Aeronautics Board, these government cartel enforcement agencies. And we were able to understand, after some lag, what the problem was there and how consumer welfare would be served by moving past that, loosening markets, allowing open competition, eventually abolishing both agencies. And the results have been nothing short of phenomenal. Environmental aspects of those deregulations or agency phase out, so to speak, were very pronounced as well. Anyway, when you talk about major reforms in antitrust and you have bills, for example, to try to make it harder for platforms to acquire nascent competitors, well, if you actually look at the amount of merger activity amongst these GAFM platforms, it's very, very small in comparison to other tech firms or the market as a whole, adjusting for size and life of the firms. And the actual examples given as problems, this is what Crandall and I do in our 2022 paper. One of the standard examples is Android. Google acquires Android in 2005. Android is a startup, has no actual software platform, has no services and no revenues, had 6 or 7 employees, but Google, thinking ahead about what might happen before the iPhone is released, buys this nub of a competitor. The idea is now, with the legislation you're talking about, driving reform possibly, that this was anti-competitive. That if Google hadn't gotten in there and bought Android, Android would be a major independent platform, not tied with any other large digital platform. It's entirely fanciful. In fact, Apple comes in 2007 with its iconic consumer innovation of the iPhone. They introduced the App Store. The following year, they create this great ecosystem. Great's a technical term. And it takes the market by storm. It wipes out the existing competitors in that market, RIM BlackBerry on the one side, and Nokia, Symbian, with their software, Symbian software platform on the other. And Apple's off to the races, only to see the rise of Android, i.e. Google, come and offer another great competitor in that space. Now, it was clearly pro-competitive to have Google be able to buy this software and develop it and make it what we call Android today, nothing even remotely similar to what it was. And that platform outcompeted, for example, Microsoft. Microsoft made a big run. In fact, in 2005, the big software for mobile phones was mobile Windows. And Microsoft integrated, they bought Nokia Symbian, which was the leading smartphone platform prior to the iPhone. Microsoft integrates, does what Microsoft does, tries to make it its own platform. Within a couple of years, they're writing off about $8 billion in losses because they couldn't compete with Apple or Google. Okay, so the idea that there was a simple pathway that we can look back and see for this startup Android to be its own independent platform is entirely uncompelling. It was very pro-competitive to allow that sale, that transaction in hindsight. And this is an example. These are the cherry-picked examples. If you go through the whole list, you'll find that there isn't a lot that's more compelling. In fact, in the Android Google merger. So we have to be very careful about these wild swings. And if you simply examine some of the assertions made in support of the new measures, you'll be, I believe, underwhelmed.
Reaction, Andy? Or?
Questions?
Is that your phone buzzing you?
No, this is my phone. I'm getting a call now. Let's just take S2992 and talk about. I want to pick up on some of the important things, many important things Tom said. First of all, the bill is kind of an admixture of law enforcement and regulation. So it's a little different in that sense. The provisions look very regulatory, but both agencies and all of the state attorneys general would be authorized to enforce it. That should give us pause as to what it might actually produce, because it won't produce a coherent regulatory scheme. Maybe that helps to break down the danger of capture, but in kind of a weird way, given the likelihood that you're going to have very, very different priorities in that group of enforcers as to why to bring a case and what is self-preferencing and so forth. Second is, unlike any antitrust bill that I know of previously, it is targeted by design at a small group of firms. I don't like that. I think that it would be a mistake to have a bill that's based on market capitalization when everybody knows it's going to be limited to a small group of firms. And that's why it's bipartisan. Well, duh, we should all have some cause for concern when there's agreement about let's get these guys, because the reasons for getting those guys are different across the aisle. And put that together with the penalties, which are based on the entire size of the enterprise, not anything calibrated to any actual violation. Put it in the hands of a lot of different people, and I think you have a really bad precedent brewing for how we should be doing competition policy. Final point I would make about that bill is there's absolutely no concession. This goes, I forget who said it, but about the original House report that sort of became the basis for the bill. There's no concession to any consumer value that these companies have delivered. There's no concession to their growth as a result of success and consumer value that they've delivered. There's no concession to the possibility that what's being described as discriminatory or self-preferencing was the function of a very long-term trail of consumer choices for particular kinds of products. Put that all together, and I think it's just a bad precedent. And going forward, I would hope there would be some humility on the part of some of the folks supporting it about the precedent it sets for future bills targeted at specific companies that are being disfavored by various groups for basically political reasons. So I don't think we need to get beyond that to really be concerned about the intended for some and unintended consequences of that particular bill. It is not a good idea for antitrust. Does that mean that there's no need for reform? No. I think there were other bills that were more open to the general applicable approach of the Sherman and Clayton Act to let's change standards applicable to all firms. And the last thing I would say about that is I don't think when you get to the conceptual level, I don't think you can protect all of the rest of the economy from the conceptual viewpoint in that bill. What will self-preferencing mean and what will the private bar do with it for other firms? And surely there are firms of smaller overall capital size that actually are larger in particular markets that would fall outside that bill. But the thought process for the offenses, the way they're defined, will appear, and merger guidelines are not going to be just for the tech firms. Concepts of nation competition, concepts of efficiency for better or worse. If these things change, they will change for everyone. They will change for all firms. And so I think it's also a mistake to sort of dismiss this bill as just, it's not our problem. It's just about big tech, and they should worry about it, but it's not going to affect us. As a precedent and in terms of its content and theories, it will affect many different things, as will new merger guidelines.
I'm worried about getting rid of self-preferencing because every time I go to the grocery store, I buy the generic brand, and my wife hates it. But that's what I like to buy. So if it's going to go away, it's going to go away. I mean, we've had self-preferencing for decades in grocery stores. I don't understand. I kind of like it.
No, the bill's going to apply to you, Barry. You've been expressing your self-preference.
We have just a very short period of time before. Did you have a question? Or?
Moderator's privilege, I get one.
Okay.
I'm going to, I think, direct it at Andy. I think I'm going to direct it at Andy and Barry, but I know from experience I will not be able to stop Tom from answering.
We'll let you go first.
Here's the.
You know about that.
So, to run a revolution, you got to win some cases, right? You got to put some points on the board if you're going to have a revolution or even an inflection point. They're not doing that. They're 0 for a lot on the merger front in particular, and I think it's pretty interesting because the win rate for the agencies, sort of historically, last administration, the administration before that, the administration before that, 85 plus at the FTC, upwards of 90 at points, and OFER doesn't get you there, or sort of even close. I think both Andy and Barry sort of tucked in maybe some hypotheses about what is going on, and correct me if I'm wrong, but you can think about a bunch of reasons why they're now 0 for a lot. Barry suggested maybe at the DOJ that will turn around, and they've got sort of good personnel, but you can imagine changes in personnel. Maybe it's just random, and the win rate will sort of jump back up to 90. Though I'm a skeptic. But personnel changes. Changes in the law, I think I heard you suggest, Andy, but I don't know of one on the Section 7 standard that would explain the change between last administration. I mean, it's a dramatic change, and maybe there's something you've got in mind, or there's sort of some other things going on. Could be wild theories. You read the complaints, the theories don't look wild. Could be the gap between the evidence mustered that you can put in front of the court and what's in the complaint. But if you just look at the win rates compared to history, I think it's a really interesting point. I mean, you've got this ambitious agenda, which you guys have sort of done the work of discussing sort of all corners of it. Why are they losing all their cases?
So I think I'd start with what I think they would say about that historic win rate, which is that it shows how timid the agencies have been. If you're winning at this high rate, it means you're not really trying to push the envelope. You're bringing safe cases. And we know that they've said that. So that's their view. We could debate whether that's a valid view, an invalid view, but certainly if you're losing everything, you go to the other extreme, there are some bad signs there. So I think one important question is what characteristics do these cases that both agencies have lost, what characteristics do they have in common? Is it really a pushing the envelope? As I said earlier, I'm not so sure that it's really pushing the envelope. So what is it? Is it bad preparation? Is it weak evidence? Is it bad case selection? What is that? It is still early. If their thinking is, we're showing Congress we need legislative change, that's a hell of a way to run into a wall. Solzhenitsyn once wrote a book called The Ram That Butted the Oak. I don't think it's a good model for antitrust agencies in the US. Good for a dissident, not for... I share your concern. I want to know, what do those cases, can we as practitioners, academics, look at those cases and determine, are there common features that explain and answer your question? Why are they losing? That's a really important question. And will it continue?
So I don't think it's just about winning cases. I think if that were the goal, it'd be really easy to win them all. There's more to it, and depending on the policy goals of the administration, some cases may be brought in order to push the law, as Andy said, and that's an incremental process. If you try to take too big a step, it makes it much more challenging. Other cases may be brought because there hasn't been any law. There's regulation by consent decree, and the courts really haven't had a chance to opine on it. So you say, let's bring a case and let the courts express a view, and let's see where they think the law is. You said that Sherman Act hasn't changed since 1890, but how it's been interpreted and applied it's evolved. So there's more to it than just bringing cases to win. Sometimes cases are brought knowing that they're 50-50 at best, but they're important policy objectives that the agencies are trying to achieve, and it's not just moving the law, but also trying to be firm on how they're going to enforce the law, and it does help to win the case. It's obviously a lot better to win the case, but I think Jonathan, if you ask Jonathan Cantor, he'll tell you that even on some of the no-poach cases where they lost the actual trial, they will say it was a win because the courts recognize that no-poach is a per se offense that can be prosecuted criminally, but they lost the trial. So the changes are incremental, and not all cases are brought for the sole purpose of winning. But when you lose a lot, it does, it should be examined, and that's what the FTC did back with hospital cases, and they learned from it and changed how they approached them and turned the record around.
We're a little over time, but did you have a reaction, Tom?
Well, I'd like to ask the experts here if I have time to ask a quick question. I mean, as an economist, I've read the Federal Trade Commission complaint against Facebook. That's going to go to trial, I guess, next year. It seems like there's going to be a lot of laughter from the bench when those arguments are made. It just doesn't seem like a serious case. And I think, well, if you're the federal, and I understand was brought before the current administration came in, but why would you continue that? Well, you might well continue it. I mean, certainly it's a popular target. You want to lose that case to tell Congress we need new laws. I mean, we took a shot at one of your favorite defendants, got nowhere. We're going to need legislation. Is that I'm swinging wildly. How close does that get? I'm asking the experts.
But not very close if the administration, if Congress shifts after the election. So if you're counting on losing in order to incentivize Congress to give you more authority at a time when Congress is doubtful of how you would use that authority, at least some are. That's not a very good strategy.
Well, so you think the Republicans are more pro-Facebook?
No, I mean, that particular case, remember, it was actually a split vote, even though it was the prior.
Right.
So I don't want to comment on about the particulars
okay.
of the case, but I think you're right. They're going to face a lot of resistance to challenging mergers from that far ago, that far in the past, and say we should have somehow been able to evaluate today. I mean, they're not arguing, really, the FTC is trying to avoid arguing that, oh, we should have opposed it back then. That's not a good argument for the FTC. The question is, now that we've seen the results, should we assess the results? And the implications of that case going forward are enormous for revisiting long since settled mergers. So I do think that you're right, there's going to be resistance.
If they win, then the next one's Google Android.
Mm-hmm. The last thing I'd say about Josh's question is, worse than losing cases is making even worse precedent for yourself to have to live with. And that's a consequence of, not even pushing the envelope, but losing cases that maybe were close or winnable, and you actually start building case law against yourself. That worries me.
I think we're at the end of our time. I want to thank the panel. Spectacular expertise, wisdom, and humor. So